Ladies and gentlemen, it's time for our first panel discussion on the topic, Role of CISO in Digital Personal Data Protection Compliance. It's my privilege to invite on stage the panel speakers for the session. Shri Prashant Lokhande, Senior Vice President and CISO, DBS Bank India Limited. Shri Nitin Chauhan, CISO, Yes Bank Limited. Ms. Khushbu Jain, practicing advocate before the Supreme Court of India and founding partner, ARK Legal. She is on the way, she'll be joining us. Shri Surya Narayanan, Deputy General Manager and CISO, Central Bank of India. And our moderator for this session, Shri S. Dinesh, partner, PwC. May I now request Shri Dinesh to initiate the panel discussions. Over to you, sir.
Hello. Thank you. Thank you to IBA. This is hopefully going to be an interesting panel discussion as the topic is very, very current. The Government of India, as you all know, has enacted the Digital Personal Data Protection Act back in August, end of August sometime. And we are still awaiting the rules from a DPDP Act perspective. But having said that, the Act has obviously caused a sort of flutter, if I might say, in the banking industry as well as in many other industries, in the sense that it changes the entire paradigm as I look at it, look at the Act. Previously, when we had the Section 43A, which is now getting repealed by this Act, the regime was entirely different. And now this Act kind of asks for consent for usage of every personal information, asks for explicit consent. There is a grievance management. There is a consent revocation provision. The penalties of as stipulated by the Act is humongous, if I may say so, up to the extent of 200 crores and 250 crores and so on. The Act also mandates a lot of restrictions from usage of children's data, saying that it should not be processed, analytics should not be done, and it should not be sort of monetized, and so on and so forth. So the question to a lot of banks, especially, is to say that how are we going to construct the entire new privacy regime, right? And will it start from changing the business model? How will it start? How will banks engage with their customers differently? How do you protect the data from breach? What is the breach management that will happen? And so on and so forth. So there are a lot of questions which can be put to many individual stakeholders within a bank, right? But in this forum specifically, what we are looking at is how is the CISO's role going to be for a bank in order to comply with the DPDP Act, right? When we speak with a lot of industry personnel, a lot of people ask, saying that, especially non-CISOs, right? Saying that, the closest a privacy officer or somebody who can take responsibility of a privacy is the CISO, right? So my first question to all the panelists will be, is that correct? Because that I have my own opinions, but the general opinion that I have got is ideally CISO should not be taking the mantle of privacy, because these two are were overlapping but yet different subjects in that sense. But we will have that discussion here as well, right? But having said that, the CISOs also have a very, very important role in terms of data protection and data security, which we have been doing even from the past. But how does that change from once the DPDP has been, has gone live or has been enacted? Of course, we will await the rules and we will have possibly some time from an implementation standpoint. But that's a question that we are trying to discuss and engage with the panelists. Right. So, given this change, sir, I will start with Mr. Surya Narayanan here, right? So, sir, how do you see CISOs changing their information security strategy, if I may say so, right, in light of the DPDP Act, right? How does it change? How does it evolve to a newer version 2 or version 3, whatever that version number that you might want to call it, but how does it change, basically? If you
Thank you, Dinesh ji, and good morning to all. See, first I will try to answer the first question. That is, what is CISO's responsibility in the privacy? I will say it is partly responsible. Okay, we cannot say fully responsible because privacy can be achieved only with security. Okay, so CISO is by default responsible for security in any organization, and banks specifically. So we are equally responsible with the business department for ensuring privacy in the bank. Now come to the question. See, privacy is not a new thing for the banks. Okay, as for the banks, it's a bank is doing the privacy because we have the Banking Regulation Act and so many things. Bank is working with privacy only. Now the new act has come that is about the digital privacy because the country has gone the robust digitization initiative, and every data is in digital form. And banks or any organization can use the digital data or even possible to misuse the digital data because this act is just to avoid the misuse of digital data. Use anyway for business purpose, we have to use the digital data. Without digitization, no bank can run as of now. So now whenever we think of this DPDP, first what will come in our mind is the penalty. Okay, that is why it is so serious. If we just remove the penalty part from the act, then it is very, I think it is very easy to implement all this. Nothing great in that. Okay, but everybody is thinking of penalty if we are not doing what will happen. So why to, so of course we have to do the security measures to ensure privacy. Just if we remove the penalty part from that, then most of the things we are already doing as of now. Only thing is we have to stringent, make more stringent these activities. Because again, because of this penalty clause. Okay, so who is the benefit? Who is benefited out of this act? See, so when we talk about the general public, I don't think the general public is so much concerned about privacy. Okay, because our data, whenever our data is everywhere. Okay, general public is not so much concerned about the privacy because what is we are talking about the privacy of the PII data, whether it is your name, phone number, email, it is everywhere, everybody knows actually. Then what is great in this rule, of this act? See, when some organization is collecting the data, it is organization's responsibility to use the data for the purpose it was collected.
Correct.
Okay. Now, the main thing banks has to do for this, comply to this act is the consent management. That is the major change. Until now, this process was not there. So, banks' system should be more stringent to process the consent received from the customers. See, if customer says my data is to be processed only for this purpose, how effective bank systems are to adopt that change, adopt that request. So that CISO's one role will come to ensure that the IT systems, of course with the IT team, that we can ensure that we can process the digital data as per the consent given by the customer. That is a major thing. Otherwise, then, of course, whatever any incident happened, data leakage happened, data theft happened, we are reporting to regulator. That is a part of the regulatory requirement. Now, we have to report to the board also, data protection board. That is an additional activity. And we have to inform the customers also, affected customers. These are the some of the added, even though some of the matters are already there, these are added like responsibilities of the bank. So who will do that is entirely a question now because,
Yes.
yeah. But CISO is responsible for the complete security of the bank, and CISO is responsible to prevent unauthorized access and unauthorized disclosure of data. If some hackers hacking the data, then it is come into CISO's role. But if some data is disclosed using authorized access and some then that is the responsibility of the business team who is there. So our responsibility is that to ensure maximum security, to ensure that the data is not disclosed in any unauthorized way. That is my view about that one. And of course, because of this act now, some the hackers will be more benefited out of this one, I think. I presume that one.
Okay, that's interesting.
Because now hackers will always, as usual, they will try to take the data unauthorized from any organization. Now they can bargain with the bank. Okay, if you are not giving this much money, we will publish this one. Then bank will think that, okay, instead of giving 250 crores, okay, why to give some small amount to them.
Smaller amount.
That way they are beneficial. They will be benefited out of this act. And some of the customers, they are seeing the opportunity to I will not say misuse word, but they will try to use the clauses of the act to make case against the banks or organizations because of their data disclosure. And of course, this is advantage for CISO community also, because to ensure privacy, we have to improve our security posture. So we can also approach our board to get more funds. Yeah. These are some of the views I have in this.
Sir, I just had one follow-up question to you. So if you are saying that, hackers are going to get benefited, or there might be more, hackers from a data perspective. So do you think that CISOs will now look at incidents from a privacy perspective also when you investigate, let's say some incident has happened, or somebody has, some breach has happened in your organization? Typically the first port of call is the CISO to preside over that entire process. So now do you think that the CISO will also look at from a privacy angle as well? For you?
Yeah, of course, because privacy is not much different from the security. Okay, right. So privacy also is what part of responsibility of CISO, because whatever we are doing security measures, that is to ensure privacy only. Right. Privacy from hackers actually mainly.
Sure. Next question to you, Nitin. See, banks again are increasingly interacting with fintechs, right? In terms of improving efficiency, getting their sort of agility skills, and every fintech is focused on a particular area of operation, and therefore, in order to improve the efficiency of the bank or agility of the bank or a variety of activities to be done by the banks are also increasingly engaging with a lot of fintechs. Now, the DPDP Act is apparently putting a constraint around some of these engagements, because obviously there will be data sharing with the fintechs, by the fintechs to the bank, and vice versa, etc. So, Nitin, the question to you is, as a CISO, how do you enable the bank to integrate with such fintechs as well as balance the side of the data protection?
So, if I may start, probably I'll go back to your first question, whether privacy or security should go hand in hand. Ideally, yes, but if somebody has seen this DPDP document, it is more towards legalities, more towards concerns, more towards specific points, which I am sure will translate into different laws and acts. Focus is towards digital personal data protection of an individual. Most of these things are any which ways, in a banking fraternity, we guys are any which ways doing it in some shape and form. Majority of things are being controlled. Now, few things which specifically called out is consent. And even today, if I have to open somebody's bank account, I take their KYC document. Consent is already there. We got it on documentation sign off or something, but yes, the context mentioned for your signing or consent might be slightly need to be defined. So, my view, having a privacy guy working along CISO is a better choice, but this privacy one is also need to be aware of the legal terms and technologies. Because if we build a different segment for DPO, probably then again a CISO which is already struggling with all cyber attacks, cyber issues, regulatory compliance, regulatory documents, internal audits, this audit and that, he has to again deal with a different guy who is a DPO now.
Right.
Saying, aapko kya chahiye, let's work out and understand. So this should go in a synergy mode, number one. Number two, this document again, if you see line by line, first example given was, if you open a bank account and KYC documents being given, there has to be a clear-cut consent. Again, a customer has a right to go back to that bank or institution saying, I want to close my account. Please either forget or delete my details.
Right.
Good part again is, agreement itself says, at least for banking, and it is again my personal view, जो मैंने थोड़ा बहुत पढ़ के देखा है इसको 2-3 बार अंग्रेजी, क्योंकि legal terms हैं, so it takes time for you to digest it. It is like, if a customer even withdraws or asks for withdrawing his information, most of the things can continue if it is in legal purview, legal requirement. To take an example, a regulator says for 10 years you need to carry data or transactions, you are always ready to store those documents for 10 years. This standard is more to, this act is more towards non-financial industries, what I can think of. Reason being, banking any which ways is regulated since day one. But now the most of the examples, if you read the act, it talks about you went to Amazon, I'll take an example, okay, so delete Amazon, online website, online shopping cart, you went there, you released some information of your KYC or personal information, those things are yet to get regulated. Banking is any which ways, we are just refining, so we have too many controls available, we are just going to refine it further. But for non-banking things, even if you go for a online cab booking, you're still sharing your card number, personal details or something of that sort, including your address. Whether those are coming in ambit of regulations, no, not yet. This is the reason, is what I feel.
Absolutely.
Your social media pages, your social media links carries your information to a very large extent, including, if I am talking now, probably few words, my iPhone or my Samsung will catch and give me a advice in half an hour, are you looking for anything of this sort? So this is a good act, and I feel it should not be taken as a stress to our ecosystem. Banking, I'm sure it's just going to be another checklist we have to build, more thorough towards customer information, consented, and then go back and see in our ecosystem, personal information, where it actually lies, because too many touch points. Now coming back to your question, sorry,
No, that's absolutely fair.
Now, this personal information goes back to my fintech partners for some reason or other. It could be as simple as somebody is sending a notification on my app saying, hey, you are, because your location is on, you are in this mall, because you are a X-Bank customer, these are the schemes going on in this bank, in this mall. Good part again from this act, and it is already there with many other regulations, it is the responsibility of principal to make sure all these data processors in some shape and size lies with the data fiduciary or the regulated identity. It's always there. Even today, forget about words like data processor or fiduciary, even a bank running a checkbook printing process with a third party, because that's not their own process, it holds the responsibility to make sure outsourcing guidelines being followed. Or right to audit, right to books, right to this and right to that, whatever. Data should be localized. So most of the things are in banking fraternity already there. Focus should be non-banking now. And I'm sure there are, and as sir said, penalties, there are too many exceptions also available. तो उससे उतना डरने की बात होगी नहीं, क्योंकि वो exception पे कहीं ना कहीं हम पाक हो सकते हैं. अगर if we can go back and find out what actually the gap is. So one line says, due diligence and sufficient security controls need to be implemented.
Correct.
It's a quite broad term. Sufficient security controls could be as simple as ISO 27001, because that's the only standard available. But then we have to go back and build our case saying, these are the controls other than ISO. I have these 20,000 controls already available, and I'm monitoring regularly. So if any organization go for a cyber insurance, primarily financial, they have a very huge checklist, because eventually they are the ones who are going to pay for it if any eventuality happens. They do a very good due diligence to make sure ये आपके पास है तो आपका प्रीमियम इतना, ये आपके पास नहीं है तो ये आपका प्रीमियम इतना. So things are there. It is just maturity this act will call for. And yes, fintech, because they are more interested in doing something like, instead of releasing an RFP request or something, they want every app should be one click and they are on. So as a regulatory entity, our control should be to make sure what he is going to process, where he is going to process, where he is going to rest or use my information. So today, if I am giving him a bit of information to send a notification, I just need to make sure I am giving him that piece only instead of giving the complete biodata of a customer to process. Number two, tomorrow if a customer comes back to me saying, thank you, I am not interested with your services, please delete my data. Data I am having with me is under regulated guidelines for 10 years. So I am safe. But it is my obligation to make sure the data which I have shared with my fintech partner need to be removed, need to be cleaned, if not required by regulators or any legal entity. So for us it's like BAU, but yeah, more slightly detailed and complex.
Absolutely, absolutely. No, that's interesting input, right? So moving on, Prashant, and as Nitin alluded, right? So given that, we just need to build one more checklist or whatever it is, right? So what do you think, and the act is somewhere right now in the, if I may say, in the gray zone, given that the act is there, it is live, but the rules are still not there, right? So how do you sort of, as a CISO, look at, so what are the initial steps that you would start proactively to anticipate and mitigate the risk, especially from a data security and a data breach perspective? And also if you can answer the other question that I asked initially as well.
Am I audible?
Yeah, now,
Thanks.
yeah.
Okay, I'll do one thing. While I take your third question, I'll link the other two questions.
Sure,
also,
sure, absolutely.
with reference to my views.
Absolutely.
I'll start with a lighter one. Because of this act, the good days have come for two fraternities. One is hackers and one is lawyers. Sorry, I'm missing my lawyer friend here. Definitely, I would have liked to take her views also. Why lawyer? Because a lot of customer awareness will come in terms, because of this act, in terms of the privacy of their data, and of course the work of CISOs is going to increase in that way.
Right.
So I'll connect the first two questions. Before that, I'll just read the preamble of act. It says that act provides for processing of digital personal data in a manner that recognizes both the right of the individual to protect their personal data and the need to process such personal data for lawful purpose and for matters connected thereto and incidental therewith. So why I wanted to take this preamble is, it has two parts. One is right of the individual to protect the personal data, where definitely it matches with the current CISO
Right.
roles and responsibilities. The second part of it is to the process, need to process that for legitimate purpose and for matters connected thereto. So there are two frameworks which are emerging here. One is definitely, we had cybersecurity framework as per various regulatory guidelines and all, which talked about security of the systems and all. Data was one part of it. Now what is coming because of this act is a privacy framework, the entire privacy regime and the framework which is coming,
Right.
which consists of two parts, because the preamble itself is clear. And what has good thing of the act is that now CISOs have started learning the legal terminologies of the act, because they would have to do that. There will be a close collaboration with
Yes.
the legal team in the banks. I'll talk more specifically from the bank's perspective, because the group here is core
Yeah,
to
yeah,
the
completely
bank.
banking.
Yeah. So it will have a lot of close collaboration with the legal team and the CISO team. I'll tell you why. Because the act has two parts. One is the privacy part, which talks about consent, limitation of purpose, then your limitation of usage and storage, It talks about right of the individual to erase the data or to ask for the correctness of the data, and also ensuring that data is correct and processed for a legitimate. That entire come as a part of your privacy framework in the bank, for which you will have to have a data privacy office.
Right.
I'm avoiding the term data privacy officer because the law itself says data protection officer. Ideally, it should have, the law should have specific to say data privacy officer. That would have been correct terminology, because the law is heavily inclined towards the processing part of it.
Correct.
Of course, protection is there, but if you see initial part, there is a lot of work on consent. There's a lot of work going to happen on the limitation of purpose, storing, retention. I'm forgetting, because
Yeah.
it also says that data should be written as far as it is required for that purpose. The moment the purpose is over, the data should be. So all that part is currently outside the sight of CISO, because that is guided by banks' data retention policies or the legal aspects of it, which is part of your technology day-to-day processes as well as the business processes together. So when I say what is the role of CISO evolving because of this, first point is definitely close collaboration with the legal team. That is there. Second thing, if you see the data protection, which the Act talks about, it lies at the intersection of your cybersecurity and the data privacy. So when you combine both the frameworks, your privacy framework and your cybersecurity framework, at the intersection lies the data protection. That is the common part which CISOs will have to look into.
Right.
When I say CISOs have to look into, is they have to, nothing, I mean, it's not something very different they have to do from the day-to-day matters. They have to see their existing policies in terms of the data management or your existing information classification and handling standards in the bank, which guides the users how to use their day-to-day data when in the normal use. They have to see the data management policies of the bank. Definitely, all of us, like, we have full-fledged data analytics wing currently, because data is new oil today. We all know that if you have to be in a competitive age, you have to harness the data, you have to derive a value out of it, and it forms part of your strategy. So you cannot leave away with the data. When you are forming the strategy, you will have to continuously analyze. You have now machine learning models, you have artificial intelligence model, you are using the data. You have to be conscious that now a new regime or a new law asks us to use it responsibly. Because now there is more responsibility on your shoulder. Earlier, that responsibility was because you had a data management policies in the bank. But now that responsibility is more because there is a statute, there is a law. You are now answerable to a government, and also now a front customer, first of all, because he will now come in front of you. Earlier, that part was missing, because you were assuming that I'm using the data responsibly. You're asking customer to give the mobile number on the pretext that I'm taking mobile number because I want to send you a 2FA OTP for your security. But you are using it to send the campaigns, offers, etc.
Right.
Your purpose were not so clear. Now you will have to be consciously working on the purpose, see whether the purpose for which you are collecting the data and telling the customer that this is a use I'm going to use, you will have to evaluate all that.
Right.
Okay, that will be an extra burden on CISO if you ask CISO should do all that, because that is something which is part of the privacy part of it. So definitely there has to be a data privacy office which should take care of all these formalities. In terms of CISO, you have to strengthen your data loss protection DLP policies. You have to strengthen your data discovery tools and techniques in the bank. Because earlier data discovery tools and techniques were used for a particular type of data, maybe like card numbers or specific Aadhaar numbers, because there were specific
regulations,
standards and regulations asking.
Yeah.
Now you will have to be consciously working on your data discovery tool to see if PII data is also scattered here and there.
Correct.
And whether it is unsecured or something. So you have to work on your data discovery tools. You have to work very heavily on training of your entire bank staff, because data is used not only by the business teams, it goes all around. It goes to finance, it goes to HR, because HR also having candidates data, staff data. It goes to your admins, everywhere. So bank-wide privacy-oriented training program is essential, apart from the cyber security.
Security, yeah.
Cyber security training was mandatory as a part of various RBI guidelines for all the staff. I feel even privacy training should also be made mandatory, which takes care of this part of the data,
Right.
like how to use the data responsibly and within the contours or within the framework of the guidelines which has come,
Right.
Act has come. So that is one part which CISO has to be wary about. And one more part is the breach. Earlier,
Correct.
CISOs were involved with the systems breach, I will say cyber security breach,
Right.
which was information security breach. If you talk in the CISO's parlance, security breach is the terminology which CISOs had.
Right.
Data breach was a consequence of that.
Yeah.
But now the definition, as per the Act, of the personal data breach is very wide. Why I'm saying wide? Because it talks about unauthorized processing and accidental disclosure.
Absolutely. Yeah.
Okay. Unauthorized processing is something which I can understand. Again, when CISO used to talk about security breach, there was an angle of data loss. Data loss is, okay, data has gone outside the boundary walls of the organization. And that was the measure of CISO to find out the severity of the security breach.
Correct. Correct.
Data loss. Data loss is just one particular aspect of the personal data breach in the Act.
Correct. Correct.
The definition of personal data breach is very wide, in the Act.
Yeah.
It talks
Absolutely.
about unauthorized processing and accidental disclosure.
Absolutely.
Accidental disclosure is something which CISOs will not have any sight of as of now. Say for example, operations team erroneously emails
MIS.
bank statement of Mr. Dinesh to Mr. Nitin, suppose.
Yeah.
Now that will also be treated as a personal data breach because it's an accidental disclosure.
Yeah.
Maybe it may be an operational error.
Yeah.
If you ask CISO, it was not a security breach. It was an operational error because
Yeah.
the operational process somewhere in that template erroneously updated the wrong statement to the wrong.
Correct. Correct.
And it was, again, Act doesn't talk about, single case or a
Yeah. Even a single
magnitude.
case. Yeah. There is no materiality.
correct. So something which perhaps CISOs will have challenges to find out this thing because each and every breach they are saying will have to be reported to the data protection board, which will come. Whereas in terms of our regulatory framework, which talks about materiality and all that, operational errors, there is already a margin given
Right.
for operational errors.
Yes.
And to the extent you are correcting the operational errors and you are ensuring the customer is not at a loss, those were the margins provided in the current regulatory framework as per the RBI. But the new regulator which is coming, we don't know how it will behave to such kind of instances also.
Correct.
Hopefully they will take a larger view in terms of, okay, what is the magnitude of the loss to the customer, whether the customer has actually been harmed because of this or something. But those are the things which we'll have to wait and look.
Right.
As far as the third question which was there, that how we will deal with the fintechs and all that, because definitely currently fintechs work on a data basically. So Act is silent about sandboxing kind of arrangement.
Yes.
That is something which will be definitely required when banks are interacting with fintechs. There is a heavy, I will say, collaboration between fintechs and each and every bank.
Each
today.
and every man. Yeah.
That is because fintechs are much ahead in terms of the adoption of the technology quickly, technology stack, technology platform, and the smaller teams and innovative ideas. So while Act says that it will not affect the innovation part of it while protecting the customer interest, perhaps what we have to wait and see is how Act will provide such kind of platforms, a sandbox platform, for banks, fintechs to come together and do experiment, pilots, tests. What is happening today, CISO's work, CISO is asked every time, if business has engaged any fintechs or third-party partner, and they want to send some data for a test pilot or something, CISO's permission is required every time, that can I send or no?
Right.
And then we have to tell them that, okay, you anonymize, you remove this part, you remove that part, then the business comes to us saying, then the purpose will not be served.
Solved.
etc.
Yeah.
And then they come out with another analogy that the customer is common. So even they are also equally responsible to protect their side of this thing.
Right.
So why we should worry? If it is their customer also, so when we are sending the data to them, they also will have liability if the data is breached or this thing happens. I see from this perspective that some kind of a sandboxing arrangement will have to be recognized by the Act, and there where the concept of privacy engineering, that entire concept will come into the play.
Right.
Already companies like Google, Amazon, and all, they are doing a lot of research on them because they are digital economies. They are data economies, rather, I will say.
Correct.
Because they work on the data, not like banks where we work on money. We take a money from public, lend as a loan. They take a data from the public, and again, entire business is on advertisements and all. So they are more worried on the privacy part of it. And a lot of research is happening on their side in terms of how to deploy the privacy enhancing technologies, PETs,
Yeah, that's right.
into the play, whereby we remove the PII part of the data, that is personally identifiable information part of the data, and come out of the ambit of the law. Because ambit of the law is the data should be personally identifiable. If I remove that part and use the technologies like anonymization, pseudonymization, suppose, or more new technologies are coming like ZKP, zero knowledge proof. Of course, they are evolving, not yet
Correct.
commercially exploited, but soon they will come because of the act in India. Those technologies will come. So there also CISO's role will be involved, because once these technologies will come, CISO will have to actively involve to see how fairly they are treating the law and this part of it. But the efforts of the larger players in the market, like the data companies, will be to remove the PI part of it and make the data anonymized so that it comes out of the purview.
Correct.
Because if you see entire GDPR from January 2021 to January 22, the fines which were levied as part of GDPR is humongous, 1.2 billion US dollars.
Yeah.
So it's humongous. I mean, if you talk about INR 8,000 crores, in that particular thing, entire new technology can be deployed, considering, and all this has to be automated. I mean, the role of CISOs is going to be nightmare. Asking that, okay, have you deleted this data from this? Manually, you cannot check and do all these things. It has to be automated. You will have to have such kind of technologies in the bank, which will see, okay, what is the retention period of this field of data? Has it lost its expiry term? And now whether it has to be anonymized or deleted.
Right.
So that level of automation is required, because in a bank, data spreads across the systems. Even user will not come to know where it is residing. If you ask the user will say, okay, I'm using this data in my day-to-day operations. But where it is stored, even technology teams or application teams will also be hesitant to give on a stamp paper that it is stored, because data is replicating, auto-replicating to multiple systems, which are not even used by the users directly. So all these challenges are there, and those will be solved only by technology again. So PETs or entire field of privacy engineering will come at the forefront, and technology team and CISOs will have to actively work. Again, fintechs will take a lead on it. That's what my knowledge is.
Okay.
Because fintechs are more equipped to deploy them rapidly and ensure that they are protected, because they work on a digital trust. Of course, banks should also work on a digital trust, and that particular process will happen now faster because this act has come. That's sure.
Thank you. So I will just have a common one question for each of the panelists in terms of what is their view, and then we'll throw it open to audience for 10 minutes if there are any questions from the audience itself. So, sir, now that we have looked at the act, etc., what is possibly the most challenging topic from a CISO standpoint that you see that has come in this act, right? I mean, maybe one or two most challenging that you see from a CISO perspective.
Yeah, of course, one of the challenging scenario will be data with the third party, whether it is fintech or cloud or anywhere. Because banks are doing business with, now most of the banks are associated with various fintechs and all. Since we are talking about the fintechs, I am
absolutely.
taking that example actually. See, now, if bank has given the data to a fintech company within good faith for the process, business process as agreed between bank and the fintech, and of course with the customer consent, then my view will be, see, bank will take all the necessary precautions, whether it is a data encryption or data control, whatever we are sharing to the fintechs, we can have control on some sort of control on that data, who can access data, access control and all. If you are ensuring everything, then the fintech is also equally responsible for misusing the data. It is not only the bank. That is my opinion. I don't know because now this sorry telling about the lawyers' role and all. They have to take care of all these things because who is misusing data, that is important. It is not the customer has given the data to the bank. Okay, of course, bank is with the due diligence dealing the data. They're sharing with fintechs and all. And if there is some mistake on the fintechs, but they are also equally responsible because these law is for the entire country, not only banks.
Correct.
They are equally responsible, and whoever the legal system should acknowledge this one, and they are to like that is my opinion. This one.
Right. Okay. Yeah. Nitin, from your standpoint, what do you think is the most challenging from a DPDP perspective?
Hello? Challenging is, first of all, we should know our house. What are the PI information or what are the critical information we have? What are the touch points so that we can actually look in totality? Information कौन सी है, क्या store करना है? जब तक वही नहीं पता होगा, तब तक आप क्या ही control build करोगे और
And that appears to be one of the most challenging from a banking standpoint, right? I mean,
not just banking.
any organization
At least,
standpoint.
Yeah, so I just want to keep banking aside. Banking में पता है, but most of the things which are consumed by a non-banker, at least they should know कि कौन सी information critical है, कौन सी नहीं है, which is coming into the purview of this act. Banking में we should be more focusing on, because we are using customer information, many channels, many verticals. Consent need to be specific, that this is for your bank account opening, this is for your notification, this is for your checkbook, whatever. So those consent will come in much more clear context. I think that's all as a change.
Sure. Prashant?
Yeah, in terms of, as earlier said, when you are engaging fintechs, you have to, currently fintechs are not outsourced service providers because RBI has given a framework for outsourced service providers. So fintechs will not fit into that. So you will have to make a separate governance standard, maybe like you can say ecosystem partners governance model or something, and fit all your interaction with fintechs as a part of it. I mean, that standard should guide all your interaction with fintechs, how you will engage them, how you will onboard them, what kind of due diligence you will make on them overall, and also the technicalities like the data sharing arrangements with them, how you will ensure that technically the data is secured when it is shared with them, what kind of data is being shared with them, what will be the purpose. Very often it will be for pilot or for evolving some pilot or something. There you will have to see if some kind of sandbox arrangement is there where data is anonymized, protectively given to them, ensuring my customer interest is also taken care of. Because definitely you have not asked your customer that I will use your data for pilot purpose or something.
Correct,
or
correct.
You see. So you have to be wary of it when you are sharing the data, live data or something, because then that will be a straight away violation because you have not taken his consent or something. And again, the technical side, you have to ensure if you are engaging APIs, etc., through which the interaction is happening, build all the security in the APIs so that they are not exploited. Because very often the data breaches are happening because of the unsecured APIs.
Right.
So you have to ensure security of your API platform and all that. So those are the additional considerations.
Sure,
yeah.
sure.
Just I want to add I'll take 1 minute actually. See, as a best practice, whether it is technically feasible or not, my viewpoint is that, see, we have to take minimum data from the customer for the just to run the business. Okay, that is one thing. Second, the consolidation of database. Now the PA data is in every database. So whether it is because different applications are talking to each other for just to transfer the data, but the PA data is everywhere. But if you can see some sort of consolidation, like some of the PIA data is in 1 or 2 main database, then it will be very easy to monitor and
Correct,
Okay.
absolutely.
It's also one sort of thinking for all.
Yeah. So that can be one of the, ways in which maybe banks can look at how do you segregate and consolidate PII data. Of course, subject to feasibility, because that's another challenge from a feasibility standpoint, because we have developed a sort of 100+ sort of applications over a period of last so many years. But yeah, but thank you all of you for extremely insightful points. I would want to throw it open to audience if anybody has any question. Yeah, yes sir. And if you want from any specific panelist, that's also fine.
Yeah, no, any panelist can answer. See, actually, when we talk about this data, and we also talk about IT department, so IT department is known for first line of defense. So means they are also known as they are custodian of the data. Means honor is business vertical, but they are custodian. So whether in terms of DPDP Act, whether IT department, some senior persons also can be appointed as a DPO, or what is the thought process of you on this?
Okay.
Anyone can reply.
Anyone can answer.
Actually, as I earlier mentioned, am I audible? Yeah. As I earlier mentioned, the law has two parts of it: entire privacy regime and the data protection regime. The law is, in my opinion, it is heavily inclined on the privacy part of it, like consent, purpose, limitation of use, storage. The protection is important, but if you see the BAU activities which are going to happen, they are going to happen on the processing part of it, for in the way it is being used, meant to be used. So even your day-to-day queries which will happen, those will be heavily inclined on that part. And that is the reason, in my opinion, the DPO should not be from tech or CISO function. Ideally, if you ask me, it should be from legal function, but that is my personal opinion. Because it will have a lot of legalities which will be involved. When actually the data protection board will come into the play and all that, you will have day-to-day queries which will be raised by the customer. What data you have, is it correct? Why you are retaining this? Or delete this data or something, which technology or CISO will not be in a position to handle this day-to-day queries. That is the reason it should be outside this thing. That is my view, but yeah.
My 2 cents, you may like it or not, but till the time we have this security or IT function or different function or uska function or iska function, we are not going to get a value for our organization, rest assured. So IT function, though they are first level of control, but it should be gelling with security, as in let's work together and get it delivered. Parking it to कि IT का कुछ IT head को हम DPO बना देंगे will not help us, because he doesn't have information, knowledge, background. He eventually will end up doing something fishy which we are not aware of. So till the time security and technology functions work in tandem, we are not going to achieve security, rest assured.
My viewpoint on that is that, see, who is a DPO, that is of less important. Okay, once is appointed as DPO, what is his role? That is very, very important actually. So whether it's IT person is appointed DPO, then he has to follow the requirements of as DPO. And instead of one single, it is a DPO committee will be there, should be there, of course with the legal team and CISO team. That will be the best approach, because it's as a team, we can ensure that these privacy requirements are achieved.
Right. Absolutely. And privacy is sort of a mixture of many competencies. So we can say it's a mixture of 3 or 4 competencies, or it's a completely new competency, whichever way we want to look at it, right? And as Prashant mentioned, we had just done a back of the envelope calculation. Even if 1% of customers start raising queries, as he was saying, you will need at least 15-20 people to only manage those queries, which in retrospect will not be a CISO's operation, because then the CISO and that function will only do that and actually leave the security of the bank in that sense. Yeah. Sorry. Any other questions? Yeah.
And here one more thing, sir. Actually, if any customer closes his account from the banking system, means the entire data to be deleted or removed from the system. As far as the PMLA Act, we can keep the data for certain period, as per our retention period, as per record maintenance policy or retention period.
Right.
With respect to third-party service provider or fintech or any outsourced services, we are having one class with their agreements. On termination of the services or agreement, the entire data should be deleted from their end. This is what we are having in the agreement. But for single customers' data, we cannot ensure that the thing was deleted at their end. Say for example, if on termination of any agreement or services, we are doing a system audit, and whether the data pertaining to our bank is there or not, we are checking it up and we are ensuring. But when a customer closes an account with the bank, so they need not be kept with our bank. So we are keeping it for as per PMLA Act. But the service provider, they may have that data. So how to manage that protection and other things? Even after closure of account with our bank, the customer data might be there with the service provider.
Yeah. So essentially the question is, even if we are only storing or archiving the data from a PMLA perspective, how do we ensure that all the third parties to which the customer data has gone is actually deleted or actually removed from that particular third party services? Any one of you can answer.
Yeah, I think that is possible through agreement only, because as a bank we cannot go to their system and check. That is not practical. They are
Actually,
to
as per our agreement, only on termination of the agreement with the service provider, the entire data will be deleted.
So
yeah. Now, if this is the requirement, we have to revise the agreement. That only agreement. This might be.
In every your agreement with the vendor, you will have data retention clause also, and that has to be periodically checked. Say for example, you may be having half-year site visits at the vendor site.
Yes.
When your team goes for the half-year site visit, you will check actually on his system whether the data is retained by him for the earlier period. Say for example, you have a card embossing vendor,
Yes.
outsourced. When you go to his site, of course, as a part of your agreement, there is a standard clause. When you go to the site, you actually check whether he has deleted this thing by doing some sample check on his system or something. That is how you can ensure that, yes, periodically we are actually checking also. Apart from that, your valid concern that even if he say carves out, takes it outside the system, then it is a part of, I will say, straight non-violation of violation of the agreement terms with him.
Yeah,
And
actually,
definitely-
with respect to card and checkbook and other things, this is a temporary nature. Once if the task is completed, they remove the data. That is that we are checking it. Some of these services, we cannot expect the same type of services with all third-party service providers. In such cases, they may retain the data. That is a. And moreover, one more thing, as per the PMLA Act, they are giving 7 years, and now they brought down to 5 years and other things. But unfortunately, when notice is received from Enforcement Directorate or something, they are seeking data from for the year 2004 or 2003, like that. In such cases, how to act?
So, sir, that's a debate that we'll have to, we can keep debating on this one, right?
Okay.
So that's the problem that we'll have. So we'll
No,
expect
actually-
some more rules
Actually,
or
if
some.
the customer is a ongoing customer and still he is having account with us, means we can readily give. They might have closed their account by 2007 or 2008 itself, but they are asking the data for 2004. In such cases, actually, why I am telling these things means, as that Ms. Advocate Madam, Gushpu Madam is here now. That's what my.
I think let's put the problem in front of her now.
Yeah. So, that's the thing that.
Yeah.
It's a question for her.
So, given that you have absolutely stepped in at the right time, so his question essentially is that, even after, let's say customer has said that, he's closing his bank account, and we are, let's say, archiving the data because it's a PMLA requirement, and therefore we have to store the data, but we'll have to ensure that the third-party processors are deleting the data. But he's also asking a question that after 5 years or 7 years or 10 years, if the enforcement directorate comes and asks for that data, and where all has it gone, then how do we treat both these sides?
Okay, so first of all, when you say right to be forgotten or right to deletion, let me go a little back. It has to be acted upon. But in scenarios like a regulatory compliance or where law enforcement agencies has mandated you to keep certain data, you have to segregate that data that, okay, for 5 years or for 7 years, there's a requirement that this data has to be kept. After 7 years, you don't have a responsibility. Let's say PMLA talks to you that, okay, 9 years or 6 years or 7 years, this data has to be kept. What kind of data has to be kept, you have to make that very clear. Now, once that is clear, then you have to make sure that you exercise that right, that all other third parties' data has been deleted. When you exercise that right, like for example, today, I close my account with you and I say I need to request for deletion because I've closed my account. That's where you give a pop-up that we are exercising this, we are acting upon this right of yours, but there are certain requirements for which we have to keep the data for 7 years. But that bookkeeping, that record keeping has to be maintained by you. So let's say that data has been shared by 20 third parties or the sister concerns of yours. That record has to be maintained where, apart from yours, rest all other places that request goes and they delete that thing. So that tomorrow after 10 years, if let's say PMLA asks you, ED asks you, or anybody else asks you under PMLA, that's why you show that record of yours that we have acted upon this record and 6 years or 7 years was the time period for us to keep it. Beyond that, it's not our liability to keep it. And these are the data entries which we have it with us.
There was one last question at the end. Okay, there are so many questions. We can take only one question because we need to be on time. Yeah.
Am I audible?
Yeah. Yeah.
So I'm Asadullah Khan. So as we all know that CISOs work for the security of the data, PII or otherwise, in conjunction with the technology team or the CTO and all those things. Now this DPDP Act has come, where it talks about the data protection officer. It is protection, obviously the data is protected technologically in the ecosystem. Now the customer has to be protected from spamming, unauthorized call and things like that. The question is where the DPO should be placed, whether he should be placed with the CISO or with the operations team who is more closely with the business, who he should be independently placed and he should be interact with the CISO and the legal team and business, because it is more like saying the data is unauthorizedly acquired or shared or processed and things like that, leading to breach, something like that. My question is to Sri Nitin or anybody else in the panel can answer it.
Sorry, sir, but we started with the same discussion where the DPO should be placed. I'll revive it for you. Primarily, DPDP is more towards data protection plus legal modalities to handle for control of personal information. My personal view, it should be with CISO functionality, but the role should not only just be a security guy or data protection guy, he should have a good understanding of legal modalities as well. So there should be, it's going to be a mix where this guy understands what a legal terminology being asked and how it is translated to my particular information when some legal authority has been raised. So my personal view, it should be under CISO, but it depends on organization where they want to have a DPO function independent, rest be it, because then there is a conflict between CISO and DPO saying, ye kar sakte aur ye nahi kar sakte. Legal says yes, and you are saying no, we can't do it. So then we already have tech where CISO and tech are having their own sweet times. Now we have DPO where CISO and DPO are going to have our own sweet time. So better to consolidate and work on it.
Yeah. No, okay, last one question. Yeah, absolutely.
Hello.
Yeah. If you have a question, yeah, please.
Good afternoon, everyone. My question is based on the baseline. See, everything works on baseline, and the most important thing right now is everyone's personal data is already at large. So, I don't think like any one of us can claim that your personal data is not available in the internet or with any specific organization. Given that backdrop, how we are going to ensure that the data privacy law is going to be very, very stringent and going and ensuring that if at all any data is leaked in a particular organization can be very much singled out and said that this has come out only from that particular organization, not from any other means. But that's very, very important.
Yeah. So actually, Khushbu, yeah, if I can reframe that question.
No, I'll- it's okay,
yeah,
I
okay, fair
understand
enough,
that.
yeah.
Okay, one, let's go on the penalty aspect of it. In case there is a breach that has happened at your organization, and in the failure of not informing the board, itself is a penalty that would be imposed on you. So whether, the entire determining factors that come in place, that you kept the best of the reasonable security standards in place, and everything was in place, and hence, despite all that, breach has happened, so no penalty should be imposed on you, or very minimal penalty should be imposed on you. You'll go away with that, right? Because it's mandated for you to inform the board that something has occurred at your incident. Some incident has occurred at your organization. Failure to do so itself is a penalty, not just in India. If you look at GDPR, 2% penalty is what has been imposed in case you fail to, despite having a knowledge, fail to inform. One. Second aspect is very clear of yours, that so much of data of ours is available across, that it's very difficult for anybody to pinpoint that, my Aadhaar card has been breached here and not here. Let's say there is a
Correct.
call, phishing call that comes to you, and they have details of your Aadhaar, and that's what you get to know. Now, can you tell today that my Aadhaar is here, or my driving license is with 4 entities, these are the 4 entities? No. That's where, the other right of yours, which is right to access. So today is the place where you have to really make sure that entire data of yours, archaic data of yours, which is there with you, you still ask for a permission from them. That, okay, this is the data of yours, do you still want to continue? One. Second, I as a user can ask any of the organizations, I have a right to access, please tell me what all data of mine are available with you, for what purposes are you utilizing it, and what are the third parties there. So that brings in the entire transparency part of it. Accountability, we have to still wait and watch how this will unfold, because we have to see how this will get enforced and how capable our board becomes, and how vigilant they are into it. But nonetheless, we are in the world where none of the people now sit in the, in the criminal side also, that they take your data and sit silent if you don't pay ransom. They threat you, they'll put the data on dark web, and it will some or the other way will come out that this data has been breached of this entity. So today is not the place where you can sit silently, that hush hush, that 2 people in the organization got to know, let's keep quiet, we should not tell anybody. This not coming out, the chances are very less. And if it comes out, you lose your chance of even justifying that this breach has happened not because of our fault. So, do not impose penalty on us.
Right, thanks. And actually that gives me a good segue. Given this act, right, how do you see at least from a data principles perspective, what changes, right, from what it was to what it might be, from a principle standpoint and not from a fiduciary standpoint?
How much time I have?
You can talk typically the whole day,
Okay.
but maybe 2 minutes here.
Okay, perfect. Okay, so this act, if you talk about, this is purely pro-users. It's for you, me, all of us as data principals. So we had something called as right to privacy, which was been enforced in 2017 as one of the fundamental right and right to life, which is Article 21, via K. Puttaswamy judgment. Now that right to life came into existence,
Right.
that right to life, how do you enforce it? A right to privacy, how do you enforce it? Like, for example, basic example, if I have right to privacy, can you tell a Uber guy that I'll not give you location because I have right to privacy? Please come, I'm telling you. He'll be like, my entire user interface is according to, you have to give me the location access. I say, no, I have right to privacy. Can I come over here and not, allow them to have any writing in the register and other details because I say I've got right to privacy, sorry, I'm not gonna share. You can't do such things. But can organizations understand? So that entire kiosk, what do you understand by right to privacy? How organizations have to understand that what are their obligations, how as a data principal has to understand what do you mean by right to privacy. That's where the entire framework has come, which we are seeing today after going almost 100 amendments and 3 different changes from 2019 onwards till 2023. Now this act is practically nothing, but it's telling you that what are your rights under right to privacy, how they can be enforced, and when you enforce that, that's where it translates into what are your obligations. Coming direct to your question, what are your rights? I have got something called as right to access, right to consent. So till now, you are the data subject, right? You are the owner of the data. But in digital world, you were practically never an owner, because you have to just say yes, yes, yes. So that's why I said that you're the owner. So give a consent. When I give a consent, you have to tell me that you utilize my data, but you have to tell me why you're utilizing my data, what is the purpose, who all parties are you going to share my data with, and when you have these details of me, give me details of that. And also I should have something called as right to be forgotten. Because if I don't have that exercise, that right to exercise, which is right to be forgotten, I don't have ownership to my data. So practically, I, as an individual who is giving you a consent, should give you a consent. Without my consent, you cannot use me as a data subject. Take my data, take my consent, purpose, parties involved. I can recall my consent. Because data, now we call it as data, is very oil, gold, and what all things which we keep on saying. And we see data has a lot of importance in life. So I should have a right to nominate. So, in the event of, let's say, unsoundness of mind, or in the event of death, which is something which is not seen in the world, which we have it in this act, I can nominate somebody else in my will. That, this is the person who I nominate for my data. Can be for beneficial purpose, for the money, for the financial gain, or can be for the purpose. It has been said that by 2030, there would be more dead profiles online than people who are alive. That's where you can exercise that right, that you can ask somebody that after my death, please delete my data, or recall, or exercise the right to be forgotten, because I don't want to be the data subject lying around. So these are your practical rights. Everything which you used to see that I can't, and I'm handicapped, and I'm under the tech giants thing, today, no, you've got entire ownership. So whatever you used to feel till now, that has all been given to you, and this is the place where you can exercise your right. All these entities are now being mandated, because they can't, wherever in the world they sit, they can't just not give you an access. They have to give you a grievance redressal mechanism in place. In case they failure to do that, in 30 days you can approach the board which will be formed under this act, and you can file a complaint. So if they don't give you something called as right to access, right to grievance, right to forgotten, right to nominate, right to alter, or make amendments, these all rights are not available. Principally, they have 50-50 crores penalty, up to 50-50 crores penalty each, just by non-compliance of this. I'm not going on the aspect of breach
Incorrect
or
data.
incident that is happening. I'm purely on the compliance aspect of it. So this was something which was ethically or morally companies should have done it, which has not been done, and this is where this act, first side of act, is talking all about.
Thanks. Thank you. Thank you to all the panelists. I'll give it back to Rahul.
Thanks indeed to the distinguished panelists for the insightful discussion on the topic, and thank you audience for making the discussions more intriguing. Now may I request all the dignitaries for a group photograph. Sir, ma'am, please be on stage, please.
रियली वंडरफुल डिस्कशन. और मुझे जैन मैडम थोड़ा पुरानी पिक्चरें याद आ गई. कानून एंड में आता है, एंड दे ऑलवेज हैव द राइट लास्ट वर्ड. थैंक्स मैडम.
Apologies for being late.
No, I never said, but we know that, Thank you very much.
Evidence great नहीं कर. Thank you, madam. Thank you. Small minute. Thank you. Thank you, sir. Thank you. Thank you. Thank you, friends. Thank you all.